Hello, I'm Keith Cooperschmidt, the CEO of the Copyright Alliance, and I want to welcome you to this installment of the Copyright Alliance's Copyright Academy. Today's episode is part of our new series on the Copyright Claims Board, or CCB for short. Now, in this series, the Copyright Alliance staff will take an in-depth look into the processes and procedures of the CCB for copyright owners who are looking to understand more about the CCB. Today, we will be talking about filing a claim with the CCB. In our first CCB video, we discussed fees and costs. I hope you were able to watch that one, because at the start of that video, we defined some of the terms that we use to refer to the parties involved in a CCB suit. Now, in case you missed that video, I'm going to take a minute here at the start of our discussion today to go over those again, just to make sure our listeners are familiar with the terms that we'll be using throughout our discussion today when we talk about the parties. So, with the first term I'll define is the term claimant. A claimant is the party that files the claim with the CCB, and that's what most of what we'll talk about today is going to be about. It's going to be about the claimant who's filing the claim. So think of a claimant. When you think of a claimant, it's similar to the person who's referred to as a plaintiff in federal or state court. The party that the claimant is suing is referred to as a respondent. A respondent is similar to the person referred to as a defendant in federal or state court. And just to close the loop, although I'm not sure we will actually refer to this person, if you will, during the course of this discussion, when a respondent responds to the claimant's claim by filing their own claims against the claimant, they are also referred to as the counterclaimant. In other words, the counterclaimant and the respondent are the same person. It's just a respondent who filed a counterclaim against the claimant. Okay, so we've got that under our belt. Hopefully everyone understands the parties' names and what we'll talk about here today. So with all that information in hand, let me introduce Terica Carrington. Terica is our Vice President and General and Copyright Counsel for the Copyright Alliance. And to be honest, she is also one of the nation's leading experts on all things related to the CCB. So Terica, welcome on board.
Thank you. Thank you.
Sure. Let's begin by talking about the types of claims that can be brought. I think this is a fairly important issue because we've seen claimants file a few claims so far with the CCB that the CCB is not allowed to hear. We don't want that to happen, right? So can you please explain what type of claims can be brought before the CCB?
Yeah, sure. Definitely. This is definitely really important information. So there are three types of claims that can be brought before the CCB. The first are infringement claims. So if a copyright owner believes someone is infringing their work, they can bring an infringement claim against that person. The second type of claim are declarations of non-infringement. If a copyright owner has accused someone of infringement and has either threatened to take action to enforce their rights, such as in a cease and desist letter, or has sent a DMCA takedown notice, that person can bring an action before the CCB seeking a declaration that the activity is not infringing. And the third type of claims are Section 512F misrepresentation claims. These types of claims are available to both copyright owners and users of copyrighted works. So a user who receives a DMCA takedown notice can challenge that notice if they believe the sender knowingly misrepresented in the notice that infringement is taking place. Similarly, creators who sent a DMCA takedown notice and then received a counter notice from a user can challenge that counter notice if they believe the sender knowingly misrepresented that the infringement was removed or disabled by mistake or due to misidentification.
All right, so I think that's pretty clear, but just in case, because we do not want claimants to make a mistake here. So just in case it isn't, can you then now discuss the flip side of that question? In other words, what type of claims cannot be brought before the CCB?
Yeah, so this is a perfect follow-up to the last question. I just listed the three types of claims that the CCB can hear, and those are the only claims they can hear. They cannot hear any other types of claims or counterclaims. So for example, the CCB cannot hear copyright ownership disputes or disputes related to other forms of intellectual property.
A claimant is not restricted to filing only one claim at a time. So if they are filing more than one claim, how do they determine whether they should file all those claims together at one time or to file them separately in multiple cases?
So if a claimant has more than one claim, those claims can be filed together in the same proceeding if the claims arise out of the same allegedly infringing activity and the total damages recovered by the claimant for all of the claims are within the limits allowed by the CCB.
All right, so let's move away from the type of claims and talk about who can bring these claims. Can you talk a little bit about who can bring an infringement claim before the CCB? Do you have to be a copyright owner, for instance?
Yeah, great question. So I know Keith defined this term already, and I have used this term already, but as a quick reminder, someone who brings a claim before the CCB is referred to as the claimant. So the claimant must be the copyright owner or the exclusive licensee in order to bring an infringement claim.
All right, so we know about infringement claims. What about declarations of non-infringement? Who can bring that type of claim?
A user of a copyrighted work can bring an action before the CCB seeking a declaration that their use of the work is not infringing, but only where there is an actual case or controversy. So in other words, there must be a conflict or dispute between the parties about whether the use is infringing. So for example, the user of a copyrighted work could seek a declaration of non-infringement if a copyright owner has accused them of infringement and has threatened to take action to enforce their rights or has sent a DMCA takedown notice. On the other hand, if someone is, for example, planning to use a copyrighted work and just wants to be sure that their use would not be infringing, this would not qualify as an actual case or controversy, and that person could not bring in action for a declaration of non-infringement.
All right, that's very helpful. So we've covered two of the three permissible claims. Let's tackle the third type of permissible claim. Who can bring a claim for misrepresentation in a DMCA takedown notice or a DMCA counter notice? And now, before you answer that question, maybe you can start off by giving us and our listeners a bit more background about exactly what a misrepresentation claim is, because I think that's one of the more confusing claims. Is I think people understand what an infringement claim is. I think they understand declaration of infringement, maybe not so much misrepresentation claim. So before you get to answer my initial question, what exactly is a misrepresentation claim?
Yeah, so I'll definitely give some background on that and also just a little bit of background about the DMCA as well. So in 1998, Congress updated the Copyright Act to combat copyright infringement online. And one of the ways Congress sought to address this issue was by creating the DMCA, also known as the Digital Millennium Copyright Act, which added Section 512 to the Copyright Act. One important aspect of Section 512 is that it sets out a procedure for copyright owners to get infringing material and activities removed from online. This is commonly referred to as the notice and takedown process. So getting back into the answer to the question, a user who received a DMCA takedown notice from a copyright owner can bring a claim for misrepresentation under Section 512F if they believe the sender knowingly misrepresented in the notice that infringement is taking place. And then on the other hand, creators who sent a DMCA takedown notice and then received a counter notice from the user can bring a claim for misrepresentation under Section 512F if they believe the sender knowingly misrepresented that the infringement was removed or disabled by mistake or due to misidentification.
Okay, so I'm going to throw you a curveball here, right? We've talked about permissible claims and who can bring those claims. Let's say the claimant co-owns a copyrighted work. Can they bring a claim alone, or do they have to bring that claim jointly with the other co-owners of that copyrighted work?
They can bring that claim alone, but the respondent also has the ability to challenge it and request that the CCB dismiss for failure to join a necessary party. If that happens, the CCB would hear arguments on the issue from both sides as to whether that party is in fact necessary and make a determination, which would take into account any existing precedent in federal court.
Okay, so we're walking our way. We know what the permissible claims are. We talked about claimants and who can bring what type of claims, but what we haven't talked about is the respondent. And just to remind everyone, the respondent is the person that the claimant is suing, the equivalent of like the defendant in federal court or state court. So let's talk about the respondents a little bit. Are there any limitations on who the claimant can sue in the CCB?
Yeah, so there are certain persons and entities that cannot be sued before the CCB or may only be sued under certain circumstances. So I'm going to go through a list of a few different categories here. First are libraries and archives. Libraries and archives have the option to preemptively opt out of any potential claim before the CCB and prevent a claimant from even bringing those claims in the first place. A claimant that wants to bring a claim against a library or archive should first check the list of libraries and archives that have preemptively opted out. And that list is maintained by the CCB on its website. And so they would check that list to determine whether or not the entity has opted out of all proceedings in the CCB. If an entity is not on the blanket opt-out list, a claimant is free to bring a claim against it, just as they would against any other person or entity. If an entity is on the blanket opt-out list, a claimant may not bring a claim against it unless the claimant believes that the entity was added to the list improperly. If that is the case, the claimant can challenge the fact that the entity is on the list by filing their claim with the CCB and including a statement explaining why they believe the entity does not belong on the Library and Archives blanket opt-out list. The next category I'm going to talk about are online service providers, or OSPs. The CCB only has jurisdiction to hear claims against an OSP in limited circumstances. Specifically, the CCB may hear claims against an OSP that is referring, linking, or storing the alleged infringing material on behalf of a user, as those terms are defined in the DMCA, but only where the OSP has been notified of the infringement through a properly submitted takedown notice under the DMCA, but fails to expeditiously remove or disable access to the material identified in the notice. The next category I'll talk about is foreign residents. In general, claims cannot be brought against foreign residents as respondents, but if a foreign resident has filed claims with the CCB, the respondent can bring counterclaims against that foreign resident. And finally, the government. Claims by or against a federal or state governmental entity cannot be brought before the CCB.
All right, thanks. So that's a lot of information. Just review a little bit. There are certain entities that you may not be able to sue, and you maybe probably can't sue in the CCB. Depends on the situation, right? We talked about library and archives being one of them. You talked about online service providers being another one. You talked about foreign residents, and you talked about the government. So if any respondent falls into that category, if you're a claimant, wait a minute, I got something else to think about here. I got something else to check, and listen to this video again. And then, or go online and check out the Copyright Office's resources, or our resources at, the Copyright Alliance resources, or the Copyright Office resources, and you can find more information about that. But in every other instance, you should be smooth sledding, so to speak. So what about the instance where you don't know, the claimant doesn't know the respondent's identity? What are they going to do? They don't know who to sue here. Is there anything that they can do to maybe try to find out the identity, or are they out of luck, so to speak?
Great question. If the infringement occurs online, Section 512H of the DMCA provides that a copyright owner can learn the identity of an alleged infringer through a federal court-issued subpoena sent to a service provider. And that process works as follows. The claimant must send a DMCA takedown notice to the service provider requesting that the service provider remove or disable access to the infringing content. The claimant has the option to send the takedown notice right away or to wait. The takedown notice should include elements such as the notice sender's contact information, the locations where the infringing content can be found, a description of the copyrighted work, a statement made in good faith confirming that the use of the work is not authorized, and a statement that the information in the notification is accurate and, under penalty of perjury, that the complaining party is authorized to act on behalf of the copyright owner. Before sending a takedown notice, the claimant should also consider whether the fair use defense is applicable. The claimant would then submit a subpoena request to a clerk in a U.S. District Court. The subpoena request must include a copy of the DMCA takedown notice, a proposed subpoena, and a sworn declaration that the identity of the alleged infringer will only be used for the purpose of enforcing the claimant's copyright. The clerk will review the subpoena request, and if the notice and draft subpoena are in proper form and the declaration is properly executed, the clerk will issue the subpoena and send it to the claimant. Once the claimant receives the issued subpoena, the claimant then sends the subpoena to the service provider. The claimant should also send the DMCA takedown notice to the service provider at this time if they haven't done so. After the service provider receives the subpoena, it is then required by law to disclose the identity of the alleged infringer to the claimant.
Okay, that's a lot to take in. I know, especially the last two questions I asked you. So for anyone who needs more information about the subpoena provision is not unique to the CCB. You can use it in other instances as well. So if you want more information, we definitely have information on our website about that. I encourage you to go take a look at it. And the Copyright Office also should be providing some helpful information on subpoenas at some point in the future. So let me stop there for a second. I want to thank Terica for all this great information. This is a lot to take in. It is a lot to understand, but there's also a lot more we need to discuss about filing a case. So what we're going to do is we're going to take a break here, and then we're going to continue our discussion about filing a case with the CCB in part 2 of this video. So take a breather, take a break, maybe watch the video again in case there's something you missed. And then join us for part 2 of this video, which will have more very good information and important information about how to file a case with the CCB. See you in part 2.